Hello everyone. In this video, we're going to be taking a look at an opinion piece from the New York Times that was published on December 5th. It's written by Linda Greenhouse, and it's regarding the upcoming Supreme Court case. Basically, it has to do with the Second Amendment in New York and the restrictions they've placed on it. It's funny, the perspective of this lefty here, Linda, on expanding the Second Amendment when it's the fact of trying to take back people's Second Amendment rights. These lefties just don't seem to get that. But anyway, gunfight at the Supreme Court. A push to expand the Second Amendment produces some judicial contortions. No, there's no judicial contortions. This is what's funny, is because, like Sticks, for example, said, oh, well, the Supreme Court's being activistic, and they're actually not being activistic. He's pushing this leftist belief that they're being activistic, this Democrat left belief, because he only reads the first paragraph of an article, maybe two paragraphs in, and then he talks out his ass these days. I don't know if it's married life and he's spending too much time, with the missus or what, but yeah, he's pushing their same shit. And it's because he doesn't read. And I'm sorry for going off on this, but when I saw his take on it, I was just like, dude, you're a moron. You seriously are a moron. If you had read further into any of these articles, read more than one, read more than the first paragraph, you would see that this is not the Supreme Court being, activistic, as he put it. They're not trying to legislate from the bench. That's the idea of being activistic, and they're not. So anyway, let's get into this. I don't know how the Second Amendment case the Supreme Court heard this week will turn out, but I do know this. If the subject weren't so serious, the case in its current posture, with substantial doubt about whether there is even a dispute left for the court to decide, would be downright funny. Oh, really? See, this is what's funny. She talks about funny. This is what's funny about this. She's trying to fearmonger. Okay, she's trying to scare the people because she actually realizes that this could be a situation where the left loses on their gun control, on their restriction of, an inalienable right, something the Second Amendment says shall not be infringed. And that scares her. For a window into the dynamics of today's Supreme Court, look no further than the transcript of the argument in New York State Rifle and Pistol Association versus City of New York. Which is funny because she's trying to say, look into the dynamics, because she doesn't agree. Like, she's like, oh, it's just stupid shit. No, these people on the right, they're just trying to reach. There's no case there. Nothing to see here. It doesn't work like that. Granted, we have to take our amusement where we can find it during these dark days. No, this isn't funny. See, she's talking about how serious this is, and then she talks about funny and humor and all this, because she's trying to paint this picture of the situation and say, well, these people, it's a joke. She's trying to lay the groundwork for that, because it's really not one, but got to try to trick people, got to convince those lefties that what they're doing is right, that what they're doing, is morally superior. When you're taking away the inalienable right for someone to defend their life, their limb, and their property. But who couldn't at least crack a smile at the girls' team versus the boys' team contest on display, with the three female justices beating back the gun club's argument that a constitutional wrong remained to be remedied, while Justice Samuel Alito and Neil Gorsuch creatively battled the obvious conclusion that because the plaintiffs got what they wanted when New York City amended a regulation to which they objected, the case is moot, which is bullshit, because actually Neil Gorsuch says that there could still be an issue here. I love how this dishonest bitch, because she is a dishonest bitch, she's trying to say, oh, well, Gorsuch, yeah. No, he actually said that there could be an issue here. That's because, see, I've actually read other things on this. I've actually looked into it, unlike some people who are talking about it. It's so funny, and she's like it actually matters that it's the girls versus the boys. All that goes to show is that the women on the court don't give a shit about the Constitution, and that they would use it during that time of the month. Well, minus the fact that they're menopausal at this point, Crypt Keeper freaking Ginsburg there. It's been way too long for her on that, but they would use it as a tampon. And they want to talk about, oh, well, look at the women. They're the reasonable ones. No, they don't give a shit about the Constitution. You can't even accurately report what Neil Gorsuch said here in your opinion piece because it doesn't go with what you're trying to push here. Justice Ruth Bader Ginsburg, Sonia Somatar, and Elaine Kagan dominated the first portion of the proceedings, with an assist from Justice Stephen Breyer. The four remained clearly unmoved by the array of increasingly strained arguments offered by Paul Clement, a former United States Solicitor General, to keep his client's case alive. This is so funny. Like, they're trying to paint this a certain way, and there's a valid case for the Supreme Court to be looking at here. The old rule, which the city revised over the summer after the court decided to review it, barred the city's residents with premises licenses that entitled them to keep guns at home from taking those guns anywhere else except authorized shooting range within the 5 boroughs. Now, this is what's funny. They hastily changed the law. She's trying to paint it differently, but they literally hastily changed the law when it was going in front of the Supreme Court going, oh, we know how to beat the Supreme Court. We'll just change the law. But they left it so that there was the same exact type of issues in it. But they went, oh, well, we addressed, the ones that they were talking about, which was the idea of, well, what about if you stop to get a cup of coffee? So they went, oh, well, you can go, type of thing. They said, well, what about that? What if you want to take a gun to your second home or whatever? So they quickly changed the law, but there's still the underlying issues there. And yeah. And they think, oh, that solves the problem. No, all they did was just change the law and went, oh, well, yeah, we'll just say that the issues are solved, and then we can just keep getting away with what we've been doing. That was the whole intent of the change. Mr. Clement asserted that even now, with the city having removed the contested restrictions from the regulation, the city still retains too much discretion over gun licensing and over such matters as whether gun owners could legally stop for coffee while carrying their gun on a trip to an out-of-state shooting range, or to an out-of-state home, or to an upstate home. And what's funny is, with that, okay, they do have way too much control over who gets to own a firearm, who doesn't. The Constitution says shall not be infringed. There is a constitutional issue here, regardless of everything else. Shall not be infringed. Right in the Constitution. But see, they don't want to admit that. And it's pretty sad when you have to sit there and wonder, because it's not specified, that if you stop to get a cup of coffee, they could use that to go after your Second Amendment rights. And I'll tell you right now, the left will say right now in New York, oh, no, we won't do that. Oh, no, we won't try to take your Second Amendment rights if you stop to go and take a pee or get a cup of coffee. Oh, hit the drive-thru at McDonald's and park in the parking lot and quickly eat. Oh, no, we won't do that. But one day they will, because you know what? They're just going to wait until people go back to sleep. And the second they go back to sleep, that's when they're going to start using this law, the way it was intended to get these people. Because that's what they do. They write these laws a particular way so that they can just, when they feel like it, infringe on someone's rights. And this is an inalienable right, and they should not be able to do it. Only a declaration that the old regulation had been unconstitutional from the beginning could protect his clients fully, Mr. Clement said. As a backup argument, he urged the court to send a message to lower courts that continue to uphold gun regulations a decade after the Supreme Court devised its current view of the Second Amendment as protecting individual gun ownership. Which is a valid argument. That's exactly what he's saying is 100% true. Because as I said, they changed the law to leave that vagueness in there. So you have this situation where they don't know what they can or can't do. It's like the idea of YouTube's terms of service or Facebook's terms of service or Twitter's terms of service. They leave it intentionally vague so that when they decide to fuck you, pardon my language, they're going to fuck you, and there's nothing you can do about it, which is exactly the intent here. And they want it clearly shown what they can and can't do if they're still going to have their inalienable right limited. And he's right about the fact that it's unconstitutional. I mean, Because, like, with gun ownership, I think it would send a very important signal to the lower courts, he said, to say that when a regulation like this is inconsistent with text and has no analog in history or tradition, it is unconstitutional, full stop. How about the fact of, why don't you just argue the fact that the Second Amendment says shall not be infringed? I think that's your strongest argument there, buddy, but hey, I'm no lawyer. The problem is that the court can't use a moot case, one in which a controversy no longer exists, to send a message. A finding of mootness strips federal courts of jurisdiction. Yes, but you see, just because you say something is true, you lefty, dried up old husk of a friggin' cat lady here. I mean, look at her. Look at this woman. Fucking cat lady. She probably reeks of cat piss, because of the 15 cats that she's got at her home. All right. She's got no man. She's got 15 cats. And she's just a miserable old bitch who thinks that she should be able to dictate what the morality of others is. That's not how it works. But yet she wants to try to do it that way. Oh, it's moot. I say it's moot. That's not how it works. Oh, God. The issue is still there about transporting their weapons. They can still get screwed. This is like how Massachusetts operates. They have this law that if you're in Massachusetts with a firearm and you don't have a mass license, yada, 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 you're screwed. Automatic, you're in jail. You get it's like the idea of how they treat with felons, 1 round for every round of ammunition you have, you get 1 year in prison. It's really ridiculous. And federal law says you have the right to transport your firearms. And so, I live in New Hampshire, and so, Florida has reciprocity. Even though New Hampshire is a constitutional carry state, I would have a license just for things like that. So if, say, I wanted to travel to Florida, and I'm traveling straight down to Florida, okay, I have a legal right to transport that firearm. But if I get pulled over in Massachusetts, even though I have that under federal law, they will still arrest me and charge me under the Massachusetts law of possessing a firearm, even though the federal law says that I can take it anywhere I'm traveling to. And the sad part is Massachusetts goes after a lot of people that way. And a lot of people get screwed. And Massachusetts, uses this ridiculously. I mean, it's so sad how much they use this. I mean, it shouldn't even be used at all. But they'll get people transporting their weapons on a regular basis. Well, relatively regular. And basically, they hope people are ignorant to the law. This is the type of situation where that abuse is going to be similar here in New York. And I love how, with this whole moot shit. So it fell to Justices Alito and Gorsuch to try to find some remaining point of contention that would keep alive the case they have chosen as a vehicle for expanding the scope of the Second Amendment. Not expanding the scope of the Second Amendment. Try taking back the Second Amendment. See, this is what gets me is expanding the scope of the Second Amendment. No, what don't you get? Right to bear arms shall not be infringed. Pretty simple. They seized on Mr. Clements' professed concern about whether a stop for coffee would interrupt the continuous and uninterrupted transport that the premises license, although newly relaxed, still requires. That's a very valid concern. You stop to take a piss. You stop to, at McDonald's. You stop for a cup of coffee. You have to stop at a family member's house real quick. Whatever. You're screwed. They can nail you under this. That's a valid concern. Because it says the continuous and uninterrupted transport. That's pretty clear. They can use that to go after people. The justice seemed disappointed when the city's lawyer, Richard Deering, called the issue an entirely feigned dispute and explained that the city's enforcement position is that coffee stops, bathroom breaks are entirely permissible, but they're not defined in the law. So the day that you decide to be cock-gobbling bitches, pardon my language, and you want to try to take people's guns, you're going to use that. Because we're talking about a state where we had Bloomberg, the taxing soda guy who wants red flag laws. The lefties in New York want those types of things. You're telling me This will not be abused. When you can't get a red flag law, if you cannot get someone on the red flag law, if you get one in New York, you're telling me this is not going to be abused to get them if they go to a shooting range and they happen to stop and get a cup of coffee because it's not clearly defined? Oh, your tune's going to change then. Mark my words on that. It won't be entirely permissible. It'll be like, no, can't do it. That's why we're busting you. What about stopping off for an hour to visit your mother? Justice Alito wanted to know. I think that's going to need to play out in the state courts, Mr. Deering said. Possible daylight. Justice Gorsuch seemed to think so when he said, so we have no representations to us as to what the direct and continuous other than coffee is okay. Now, you know what's funny? Let's go back up to the beginning, because I just want to point this out. Because you got Gorsuch here saying that there's an issue, but then you go towards the beginning. And, you got to love it here. Right here. Sorry, it took me a second to find it. She's talking about how Alito and Gorsuch, because she's expecting people to read one thing at the beginning. Okay? She's saying that Gorsuch and Alito basically said they got what they wanted and that the case was moot. I called it out. Now, you get down here, those same two justices going, wait a minute. The case isn't moot. So which is it? See, she didn't expect people to read this far down. And you got this contradiction and you're going, wait a minute. Didn't you just say the opposite? And I had read this before and I had that click with me, but it kind of like clicked in the back of my mind. But I was like, whatever. So, yeah, it just goes to show how dishonest these people are. Justice Clarence Thomas, who more than anyone on the court is responsible for lifting the Second Amendment from obscurity. Excuse me, the Second Amendment was not obscure. Okay, the Second Amendment, you dumb bitch, is what ensures that you have the First Amendment. To say the stupid, demented, twisted, infantile bullshit that you are here. So anyway, amendment from obscurity was characteristically silent throughout the argument, as was, more mysteriously, Justice Brett Kavanaugh. Chief Justice John Roberts' few questions have been widely interpreted as favoring a finding of mootness. But I read the Chief Justice as seeking clarity rather than tipping his hand. I love how she's just literally working stuff into this. Anyway, anyone with a memory of how the Second Amendment issue has unfolded had to be at least a bit amused by Mr. Clements' performance. Why? Because he actually said serious shit that had valid points, and you think that's funny? Jesus Christ. In private practice and serving as President George W. Bush's Solicitor General, he has represented the National Rifle Association, of which the New York State Rifle and Pistol Association is the biggest state affiliate in a number of cases. So what? 11 years ago, however, when the District of Columbia v. Heller was pending, he represented the United States and his position was a particularly delicate one. Yeah, he was arguing a case for the state. I love how they're trying to make that like this thing of, oh, well, look at these different stance. She's an idiot. The question in Heller was whether the Second Amendment conveyed an individual right to keep a handgun at home for self-defense. The Bush administration supported the individual rights position. Okay. But Mr. Clement had to calibrate his argument carefully so that a Supreme Court decision striking down the District of Columbia's handgun ban would not jeopardize several federal laws on the books that imposed restrictions on firearm sales and ownership. Yes. I love how she's trying to bring this up. So basically, he's given, instructions from his bosses. You have to do this a certain way. And now that he's in private practice, she's going to try to use this to say, oh, well, you're a fucking hypocrite. It don't work like that. But okay. For that reason, the brief he filed in the Supreme Court stopped short of asking that gun regulations be subject to the strictest judicial scrutiny, the most protective standard that courts apply to rights deemed fundamental. Okay. Instead, he offered a sliding scale that would take into account the strength of the government's interest in enforcement. Yeah, that still doesn't mean it's right. That was the Bush administration. I love this. Crooked Bush, crooked baby Bush, okay, got us into multiple wars, under false pretenses. You don't think his administration is going to use false pretenses elsewhere? Jesus. The brief outraged the gun lobby and its many friends in Congress, 300 of whom signed a brief that asked the court to apply strict scrutiny and declare the district's gun law unconstitutional per se. Unconstitutional per se. Vice President Dick Cheney signed the brief, an astonishing rebuke by a sitting vice president of his own administration's Solicitor General. Yeah, basically, he was trying to save face there because of the backlash, but all right. That would be just so much ancient history, except that history is repeating itself, offering a fascinating undercurrent to Monday's argument. Mr. Clement is obvious, she uses all this to set this up that she's going to try to say he's a hypocrite, basically, is what she's getting at here. Oh, God. You could have just come out and said that instead of putting all this bullshit in here to try to fucking make your case. Built off of a pile of shit. Mr. Clement is obviously at odds with the Trump administration on how to rebuke the mootness question. For institutional reasons, the current Solicitor General's office doesn't want to endorse the position that the repeal of a law does not automatically spell an end to a legal controversy. That's understandable because it is in the government's interest to be able to draw the curtains on a legal dispute by refraining from enforcing a policy known as voluntary cessation. Mootness can be the government's friend. Of course, this is funny. The repeal of a law does not automatically spell an end to a legal controversy. Actually, yes, it does. Because if you repeal a law, that law itself was the controversy. So now you've removed the controversy, no issue. This broad is an idiot. She seriously thinks this is like some intellectually, strong argument she's making here. I was going to say superior argument, but actually she probably thinks it's an intellectually superior argument. And mootness is not the government's friend. That's just being sleazy. If you change one little thing in a law, all right, to get past the scrutiny of it going in front of a judge, you're a scumbag. Plain and simple. You make something moot, but you leave the underlying issue there, you're a scumbag. You're just trying to get out of the fact of having to deal with having what you believe should be something taken to court and questioned. But recognizing that fact, Solicitor General Noel Francisco still wanted to do what he could to help keep the case going. His principal duty, Deputy Jeffrey Wall, told the justices that the case wasn't moot because the three members of the NRA affiliate who are the plaintiffs could still seek damages for the economic harm they suffered under the old law. It's not even that. Shall not be infringed would be a good argument. But anyway, the nature of this harm and how this concept could be raised for the first time is so late in the day left the justices puzzled. But that's not even an issue because there's still the underlying issue of if you have to go from point A to point B, but you have to stop to take a piss. What are you supposed to do? Just piss yourself? Oh, well, we won't enforce that. You will someday when you decide it's expedient to do so. To be sure, Mr. Wall had to concede the plaintiffs were not focused on damages in their legal papers. Not focused on damages is an understatement, Justice Kagan exclaimed. Mr. Wall, they filed a complaint. They filed a motion for summary judgment. They briefed this, believed. They briefed this case before the Second Circuit. They filed a cert petition. Then in response to the suggestion of mootness, they filed another brief here, and in none of those places did they ask for damages. Damages has been injected into the case because of the Solicitor General. So what? It's still a concern, and it's a valid one. So what if someone else brought it up? It's still a valid concern. They could still sue because of this. But anyway, I love how they're trying to play this. Well, because they did it, there's still that concern there. So what? Look, Justice Kagan, I certainly grant that there's a lot of Post-grant maneuvering on both sides, Mr. Wall said. He was left somewhat lamely to repeat that our view is that the damages could change hands and hence it is not moot. A good portion of what remained of the hour-long argument then focused on the property of a court considering after-the-fact defense against mootness. Oh, and the propriety. I apologize. It's not an after-the-fact mootness. There's still the underlying thing. I love how they keep looking at this as it's now moot. Just because you change a law a little bit and leave the underlying concerns does not mean that the thing is moot. And this is what gets me is Styx is like, oh, well, this is activistic. No, dude. This is literally what the Supreme Court is there for. I think Tarl needs to get his head adjusted these days. He's high on his own farts with that shit. Anyway, as I said at the beginning of this column, it would be funny if it wasn't so serious. Of course, there's maneuvering on both sides. That's the nature of Supreme Court practices these days, and it applies not only to the Supreme Court lawyers, but to the other side of the bench as well. I love this. She's trying to... Why? Because they don't agree with you? There's... Yeah. Maneuvering. Because you don't... No, I'm sorry. It doesn't work like that. They don't agree with you. That doesn't mean there's maneuvering going on necessarily. Justice Alito is an Olympic quality champion at writing opinions that invite attentive and like-minded readers to bring him exactly the case he wants in order to achieve his desired result. I love this baseless accusation. So he's cherry-picking cases. This is what she just accused him of. This is one sleazy, scumbaggy bitch. Seriously. This case offers a snapshot, a little drama in which all the players are in their assigned places. The court's liberals, who surely never wanted the case on the docket in the first place, just want it to go away. Well, of course they do, because you know what? They're anti-Second Amendment. They are anti-self-defense. They are the type that are authoritarian. They don't even like the Constitution. They basically said with Heller versus D.C. that, fuck you. You don't have a right to defend yourself. The Second Amendment was never intended for the American people. I don't care that the Founding Fathers wrote in their papers and their documents and their books things regarding the Second Amendment that clearly show that it was. They're anti-Constitution shitbags. So that's why they want it to go away. Consistently applied law at this point happens to be on their side. No, it doesn't. I love this. Consistently applied law at this point happens to be on their side. No, that's not how it works, bitch. Just because you say something does not make it true. That is not the case. Oh my God. This broad is freaking mental. She's a mental case. Law has not... So... Because the left consistently keeps infringing on the Second Amendment. You're going, oh, well, it's consistently applied law, and it backs everything else. That's not how it works. And we've seen this supposedly consistently applied law struck down, like with Heller versus D.C. So get a clue. That's not how it works. The appetite of the conservative justice for a vehicle to expand the Second Amendment is palpable. And at least some of them are willing to turn cartwheels to keep this one going. Excuse me, this is not about expanding the Second Amendment. This is about stopping psychotic scumbags like you from infringing upon an inalienable right that the Founding Fathers clearly said shall not be infringed. What don't you get about that? Go read the Second Amendment. Shall not be infringed. Pretty freaking clear. Jesus, this broad is nuts. She is cuckoo. In the faraway land of not too long ago, it was judicial conservatives who invoked the virtues of judicial modesty and relied on doctrines like mootness and standing to keep cases out of court. Now, seemingly has come down to this, whatever it takes. No, that's not what's going on. I love how you keep ignoring that because they did not clarify things and they just said we're not going to enforce it. There is still an issue because they can choose to enforce something at a point in the future. It's not clearly defined in the law. And because it's not clearly defined, and there's still the same underlying issue from before they changed the law when they tried to be shady, shifty shitbags and get out from under the view of the Supreme Court and have this heard, okay? They said, oh, we'll just change it, but we'll leave the same problems. And then we'll say it's moot. And then everyone will just accept that. And because you have justices on the Supreme Court who said, no. Wait 1 minute. Hold on one goddamn minute, you dumb bitches. The problems are still there. So here's what we're going to do. We're going to hear this case, or we want to hear this case. And now they are. And they don't like this on the left because they figure they can just change something, one little thing in a law, and they can still pull the same shit they were pulling. And now they're learning under a Trump presidency. That's not going to happen. So now they're going to spurg out and go, oh, they're trying to expand the Second Amendment. Oh, they're trying to do this. They're trying to put you in harm's way. Oh, they're trying to violate the idea of what case law has said. Well, that's not the case. I mean, they're desperate right now. They're losing on all these fronts. And this right here could royally fuck New York. This could be a case that could really screw the pooch for the left on restricting how people possess their firearms, the possession of them in general, and the transportation of them. And they know this. And they are so scared. It's funny, too. It's funny and sad at the same time. And it's scary looking at how desperate they are because, heaven forbid, God only knows where they are going to be willing to push things. You know, because if they don't get their way, look at what's happened. On the note of Trump, they didn't get their way. They're now looking to impeach him. Do you think if they don't get their way with this, they're not going to spurg out like they have been with Trump for the last 3 years? Of course they are. They are scared shitless right now that all the ground they've made is now being taken away from them. Like on the note of the Second Amendment, like on the note of, importing their voters, things like that, because they know they can't win on a level playing field. So they've had to resort to these tactics. And now that these tactics are no longer working for them, they don't know what to do. Anyway, I'm just going to leave things here. If you liked this video, depending on where you are watching it, please give it an upvote or thumbs up. If you want to know when new content of mine hits the internet, don't forget to subscribe to one or more of my social media or video accounts listed here. Also, with YouTube, don't forget to ring that bell. You can find all of my video content on both BitChute and YouTube. This may not be the case with other places I upload to, but I will try to minimize this happening. You are always welcome to interact with me at any of these sites on the list, so feel free to do so. If you have anything you want me to cover in a video, when it comes to news or current events, send it right along to me. I will try to do my best to cover it. As always, thank you for watching.